A judge in the Ryan Houston case gives her first TV interview only on News 13. She clarifies who set Houston's bond and what happened in her court.
It comes after District Attorney Todd Williams said he did everything he could to keep Houston behind bars. Houston was out on a $1.6 million bond awaiting trial in a separate case when authorities say he stabbed his girlfriend and then killed a retired police chief and himself in a wrong-way crash on I-26.
News 13's Kimberly King joins us tonight. Kim, the judge feels it's time to speak.
Holly, the hearing in Grant's court focused on allegations that Houston didn't properly charge his ankle monitor. But the judge says more information surfaced during the hearing as she challenges information that the DA put out. Is there part of you that wants to set the record straight, knowing that there has been so much discussion about what went on in your courtroom?
Yes.
Superior Court Judge Jacqueline Grant presided over a motion to revoke bond for Ryan Ricky Houston last year.
I don't do a lot of interviews, but when I came back and heard a lot of the statements, it was, this is just not accurate. This is just not factually accurate.
What Grant heard about was District Attorney Todd Williams speaking on the radio about Houston's hearing in her court.
The judge's determination was to allow him to remain on electronic monitoring. In this case, we saw a problem with it, and we asked the judge to revoke his bond.
That statement, the judge says, was accurate, but Grant says Williams wasn't in court to hear facts, just his assistant DA. She feels Williams has conflated facts and made inaccurate statements inferring she was to blame for Houston being out.
I know when people go around after the fact trying to say, well, we did this. No, there's an actual record.
Grant says she had no role in Houston's bond.
His bond was already set, and his conditions of pretrial was already set by another judge.
She also says Houston, under the law, had a right to bond.
The only time you could issue a no bond and hold someone without a bond was if they had committed a capital offense,
which is first-degree murder.
Mr. Houston had bad intentions.
Houston charged more than a year ago with attempted murder. Grant says the law at the time required judges choose how to supervise defendants waiting for trial.
You could do house arrest or electronic monitor.
A previous judge ruled Houston would get an ankle monitor, but within days, the DA's office alleged Houston violated rules, then called the hearing before Grant. We had the judge listen to Williams's account.
He had not complied with his electronic monitoring obligations by keeping his device charged.
The judge said testimony showed Houston did try to charge the device, but only 5 minutes. Further testimony, she said, revealed that wasn't the main issue.
Once you got to the hearing, that information was incorrect?
Correct. So he was off the monitor, not for failing to try to charge it, because the battery was not
faulty?
holding its charge. Correct. It was not holding its charge.
The court transcript backs up the judge's statement, a supervisor admitting the device is slowing down, and I brought another device to swap it out. Another issue, I did not receive alerts. I live way out in Haywood County near Tennessee, so I get a very poor signal. The DA's office, the transcript shows, dropped its official request to revoke bond and was now asking the judge to put Houston on house arrest with added surveillance because Buncombe County didn't have equipment.
The problem was that they were out of electronic monitors at the time.
Within days, Grant said she got notified of another possible violation she said turned out to be false. Still, she ordered Houston arrested and held in jail until Buncombe County had a more reliable ankle monitor to issue him. News 13 Investigates has since uncovered 200 issues with Houston's Buncombe County monitor, including 5 alleged violations, though Grant says none were ever brought to her attention.
Why is the court system relying on a system that has so many glitches? I'm just going to call it that because 200 is an issue. It makes more work for you, makes more work for the pretrial services coordinator. This is a flawed system, it sounds like, with an electronic monitor.
I think the issue is we have, in all honesty, what we have. You know, everything is with tax dollars, and so we're competing with everybody else in trying to get dollars for what you can afford. I'm not aware of any other incident of this occurring as far as what has happened with Mr. Houston, the end result.
Grant also wants to get other issues clarified.
But the DA never came to you and expounded on his domestic violence history. They
No.
never requested an increase in his bond.
No. I'm glad that we are having this discussion and taking a look at all of what occurred. When they're sitting down and they're making laws, you cannot envision everything that could possibly occur. It's when something happens that you're able to take a look back and say, maybe we need to do this.
So Kim, the DA acknowledged Houston's bond was significant, but Houston had wealth with a really successful landscaping business.
Holly, he did. And the DA declined our request to interview, but said in a statement in part, the assistant district attorney recalls requesting a bond of at least $2 million and advising the court of Houston's ability to post it. He also advised of events leading to the charge of attempted first-degree murder. The case was also a high-risk domestic violence case. Holly, Williams also says the judge has authority to set bonds that are even higher depending on circumstances. He's also told me his office was never informed of the hundreds of issues with Houston's ankle monitor and is now the one who called for the SBI investigation into the case. DAs I've spoken with, however, also say that due to his concerns, Williams could have moved this trial up and for shooting the officer last year. And attorneys confirmed that there's video of that shooting, which they say would have been compelling evidence before a jury.
I know you're going to continue to dig into this even further.
Yep.
Thanks, Kim.